Oh, good afternoon. Well, hasn't been that long since I spoke out here, just last night. And what a morning already it's been. But it's almost 11 o'clock in Idaho, Ada County, particularly Idaho. So we're going to be heading into the courtroom of Judge Stephen Hippler for the plea hearing of Bryan Kohberger. Did he say that all of the families are going to be there? The four victims' families, Gonzalez and Morgan and Kernodle and Chapin, but also the family of Bryan Kohberger. Well, this affects both sides, very much so. Lots of speculation as to why Bryan Kohberger has decided to plea at this time. I mean, much of it has to do with Judge Hippler's most recent decisions not to allow a continuance in the trial that was expected to go off at the beginning of August, although we did grant them a week, but also to put down the chance for the defense to bring in other suspects that could have been the naming of other suspects without evidence. I basically tore that argument apart as being nothing but fluff. You know? So welcome everyone coming in. Hello there, Rocket Couch over there in Twitch. Hi, Kieran and Jean. Shill, thank you so much for being here too. Let me just get hey book lover. How are you? How are you doing? Let's just get this let's get this hearing up. As you can see, this is gonna come out straight out of the state of Idaho. Okay, we'll see what the placement is like. Sometimes the camera is a bit wacky there. So we'll see about placement once it comes up. Shill, thank you so much for being over there in Kick. I appreciate having a mod over there. Thank you very much. Yeah. Those of you over on Twitch, thank you. Book Lover says, excited to have a live to watch with everyone while I work. I've been missing you. We've been missing you. I've been doing, a little bit in the evening. I just started back. I do have some stuff going on in real life, right, people? In real life first, always. And it's been a bit crazy. Yeah. But we're all holding our own. And there's been so much going on in true crime. I mean, first we had the Karen Reed verdicts, and then everything went to verdict for P. Diddy so quick, with the defense just, barely putting on a defense. Then we had closing statements. And the jury questions have been quite interesting in P. Diddy, but we have a verdict in that now. And those of you that are coming in may have saw that they only convicted him of the lesser charge, two of them, for the Mann Act, for actually the transportation for the purpose of prostitution for both Cassie and Jane. So there's that. But totally acquitted on the others. They'll be back in the courtroom. They probably have started already hearing arguments for the state and for the defense onto why or how he should get bail to await sentencing and when sentencing should occur. But they'll be in court for the rest of the afternoon going over that. There'll be a community post once I have all the information to give all of the details, But for now, we've got Bryan Kohberger. And this also came out of nowhere. I had no idea. I wasn't even leaning this way. I heard nothing, not a whiff of a rumor, nothing. No speculation. I didn't hear anybody talking about it, and boom, all of a sudden it's everywhere that there's a plea deal with Bryan Kohberger. And then this hearing was scheduled very quickly. Some of the families are quite upset. There's been interviews and posted statements from both the aunt, Zana Colonel, and also the family of Miss Gonzalez, that they are not very happy. They wanted more say in how this went down. They didn't like the way they were notified, especially the Gonzalez family has been speaking about how cold they believe the prosecution is in how they're handling the treatment of the victims' families from the start. They got a lot to say about it. Oh, Charlotte, thank you so much. Get you a coffee and take care. I appreciate you. Thank you so much. Thank you, Charlotte. Hey, Crazy Cat, welcome. Exactly, Karen. I say that to my mods. I say that to everybody in real life first, even before true crime or anything. We got to take care of what we got to take care of, and I'll do what I can to still keep up out here the best I can. And I am keeping my eye on stuff. And I want to thank some of my mods for jumping in my DMs whenever anything happens. Mrs. Cassandra for waking me up, man, when Brian Kohberger decided to do this plea deal. We were all set that night to do P. Diddy on Monday night, but we switched everything up. This was quite surprising. We got all the information. And then we did P. Diddy last night. And of course, that's the end of the upmates. Whoops. The courtroom has in P. Diddy, they are starting over there too. And you might have heard the music for Jesse Weber bleeding through from Law and Crime. I do like watching that gentleman as far as a lawyer over there on Law and Crime. I like it. I've been watching all of his stuff. They're also going to be live for this hearing. There is so many versions of this hearing coming up for Brian Kohberger. Last night I counted 15 scheduled. That's a lot. So y'all would have helped me not get this one buried and hit the back of the comment section when we're done. Don't forget to like and share and keep this stuff in the algorithm. There's some heavy competition in regards to these kind of things, which, hey, Liam, good to see you. Good afternoon or good evening to you. It's later. It's like dinner time by you. Yeah. I'm glad you could catch this. I do like doing the live hearings with you guys. I know that everyone would have a lot to say about this. We've been following Kohberger together for several years now. All of the hearings, all of the filings. Some of you anxiously awaiting the filings the way I do and reading all the judges' decisions, And this is quite surprising. I did not get a whiff of it, although George Hippler was pretty heavy on the law in the last denial of the motion for alternate suspects, so to speak, that the defense was going to do. It did not really appreciate. There's been a lot of pushback on that. Them just anyone who was even associated with anyone in the house, that they were going to be pointing fingers and all. And as we learned in the Karen Reed case, that can be quite damaging to a witness or to anyone affiliated with the case in some way. And people are crazy out here. That's what I'm going to say. Like, people out here online, there's a certain element that is like, well, if there's a line, they cross it. And I wouldn't wish that on anyone who's participating in a case or witness or anyone who knows the victims. I mean, their friends, all getting named in motions that, it could have possibly been them. Can you imagine reading that about yourself, out of nowhere? I do believe everyone deserves a good defense. Well, even Judge Hippler wasn't having that here, And there wasn't anything to go by, so they weren't going to be allowed to do it. The most common thread of conversation right now in regards to it is that Brian Kohberger did not want the death penalty. He did not want to be on death row or waiting for years and years and years, either a lethal injection or the firing squad. Now, let me just tell you a little bit about Idaho and the lethal injection. The last one was botched years ago. Okay, and they did do legislation to bring back the firing squad because they've had a heck of a time getting the supplies that are necessary, the drugs that are necessary, and or implementation of lethal injection. So they voted in the firing squad, I believe it was last year. Now, they've got people on death row waiting, but this last case that did get bailed, okay, that man had been sitting on death row for upwards of 30, like almost 30 years. That's how long he's sitting there. That's how long it takes when you are convicted with the death penalty for everything to go through. And, there's appeal after appeal, mandatory appeals. Chad Daypale's doing a mandatory appeal in review. I'm wondering how long before he will actually come up for his justice after receiving the death penalty. So if Bryan Kohberger did get the death penalty, the chances of him still breathing the way he would be now with a life sentence, if the plea is accepted, because remember, Hippler still has to do that. If the plea gets accepted, he gets life, no chance of parole ever, no avoids all rights to appeal. But what he doesn't say is that he has to allocate, that he has to describe the crime and give all the information. There is no demand for that. Something that the Gonzalez family has been quite adamant that they want to hear. Unfortunately, the plea may not give us all the answers, the family all the answers, I should say, that they want. But it is a form of justice. And at the very least, you got the right guy. If he's willing to plea, you're pretty confident he is the one who did it. There'll be no second guessing. There'll be no chance of a mistrial or some kind of thing going wrong where the whole case gets tossed out. There will be justice that the man who did the crime has to pay. Nope. Yeah, excuse me, there was something over in the chat I needed to take care of. But as we wait for the court, are they how do you guys feel about this? I'm just curious. I'm a little of both two heads about it, to tell you the truth. In a way, I think it is justice. It's the right thing for expenses for the state. It takes the elimination of, the case being botched in presentation or the jury not seeing the evidence the way the prosecution does. To me, it takes some of the doubt away on whether or not he actually did it. If he's saying he did it, right? So there's that, Yeah. Well, I got an echo. For now we wait. We're just waiting for the court to come up. Thank you so much, Jill, for gifting the memberships. Let's see who received those. Let's see if it says to Stephen and Rodent, Karen and Jester. Karen, Rodent, Rocky Couch, Stephen and Jester. Congratulations on receiving your membership, gifted by Jill. I hope you'll enjoy it. And later on today, I will definitely go and put another link for the Discord in so that you may, if you're not already in there, you can access the Discord where we put so much of these legal cases in there, you know. True, Liam. True. Liam says, I think that it is a good ending, stops the years of hanging on to appeals and etc. Yes, it closes the chapter, especially that part where there'll be no appeal. There'll be no back and forth. Like, in one way, yes, absolutely. It will actually help the family be able to move forward. All right. It also, the family will not have to sit through a trial hearing the evidence against Bryan Kohberger, the actions, reliving the crime day in and day out, while a trial, a very long and tedious trial, goes on. That trial was expected to go on quite some time. I mean, we've all been in the hearings. We know how things get presented by the defense. And we have heard about all of this stuff that the prosecution needed to present. I've heard from several who are quite disappointed that they won't know all the evidence, but we don't know what they're going to release afterwards, whether they will get sealed or whether evidence will be put forward. Sometimes they do, sometimes they don't. It is a high-profile case. We have to see how Judge Hippler is going to actually handle it, because all of this is putting the cart before the horse. Because just because Bryan Kohberger decides to accept what the prosecution has presented is a great plea deal for him, what he would like, the court still has to make it official. And it is up to Judge Hippler on whether or not he thinks this is justice and the right thing to do. Yep. So, the way things are going, the way the stars have aligned and the moon has shone, and the way the universe has been spinning, all of these true crime cases lately, I would just get ready for anything to happen today. That's all I would say. Like, I'm not making any bets because anything could happen. As we just saw in several cases. Like, it's really, I'm not going to hedge my bets with Judge Hippler. Although from day one, he wanted this to come to a conclusion. He wanted to get this to trial. He wanted to stop the delays. Yes, he has been moving forward. So for him, and him not wanting to be on a case like this, really looked at it as quite a headache when he came into that whole big mess with the genealogy testing. He made no bones about it. The first day we met him, he said, I remember that day. He said, I wish I could tell you I'd like to be here, but I don't want to start off on the wrong foot with a misstatement. And he would not happy to have been assigned that case. And he hasn't looked very happy about it several times in hearings and holding his head up with the long arguments and, trying to move things forward the best that he can, motion after motion, Hello, Tomorrow Kiddo. Welcome. Hello, Maggie. Right now, I really don't know what to think because I cannot answer what I may feel as a parent in that position. Exactly. My heart. I feel you, Maggie. We have no idea, right? And I never want to presume. And that's the other thing. Some people are actually speaking loudly about the family, complaining about this. And I was like, sit down. The family has every right to voice their opinion about the process. This is their justice. They are part of the process and their voice needs to be heard. Now, they may not have control over whether a plea gets offered, but they are heard about it by the prosecution. But they don't get to veto it. They should be allowed to weigh in. Their voice is supposed to be heard. Well, and they're complaining about how they were notified and what amount of say they had. They don't like the way they've been treated, and they have every right to say so. Like Maggie says, I would never want to presume to know the pain that they have going through all of this. No parent should have to outlive a child. It's cruel. It's horrible. I can't even imagine, And if they have emotions about it and feels about it, they're entitled to it. And so those are, going back and forth on Twitter, or even because certain elements of the victim families are actually active on the socials. Oh. All right, that's it for me. We're waiting. Nice clear picture. How's the audio, everybody? Let me make sure that's up for Judge Hippler. He's low. Here we go. I shall mute. Good afternoon, Judge Hippler. I see all three of Bryan's attorneys. I see two more prosecutors than normal. I will have to find out who they are. Actually, three more. All right.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and Ms. Taylor, Ms. Massoth, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Hurwit, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms. Allen is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Court should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this, because, again, it is not appropriate and, frankly, not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. If I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate That is that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count 1, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime to be enforced in the form of a civil judgment to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with, that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Is anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the resuscitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing in his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m. on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow on the Moscow-Pullman Road. This was the traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Caitlin Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. and I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to know single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the 3rd floor, it was on the 2nd floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, this Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath. as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogan's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, in public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence of 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Colonel. Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. Court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. We have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor. Thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
Would have no objection for the order to remain in place through
All right.
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn. in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
Whoa, 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 whoa. Well, they definitely included the basis of the the basis of the crime in what the prosecution did believe was what happened and what Bryan Kohberger is actually saying he did. The fact that the prosecution had laid out that case, that's exactly what they submitted to Judge Hippler, exactly what the defense received in the plea as to what they were actually accusing and what they had in what he was pleading to. So he agrees to all of it. He's not contesting anything that they said. That was a big part of it for the family. It does not include the why, but it does include the how. And it actually does include the fact that he is saying that, yes, that was me. I did it. No contest. That's exactly what happened. And that does give some closure to the family. Some. We will have sentencing where we will hear from the family. Victim statements, victim impact statements still will go through. For the first time, we heard Bryan Kohberger's voice in court, like that I can recall. Besides his not guilty plea, which I do believe, I'm not sure I heard his voice then either. I think maybe the attorneys had entered it for him, but it's pretty much straightforward. Judge Hippler being cautious, making sure every step of the way Bryan Kohberger understands what this means. He seemed solid in his understanding of it. I will say, I did hold my breath when Judge Hippler asked Ann Taylor if she had time to go through the discovery. I'm sure you all did too, based on all of the filings that say she hasn't had enough time to go through everything and she needs more time. She's filed numerous motions that said exactly that. And I did hold my breath a little, but she did say that she went through everything. I didn't hear anything new, Liam. I didn't hear anything new either. So there's a straightforward case. Pretty much what we have been hearing about from the beginning, and the little bit of extra stuff that was leaked from that Dateline interview. Yeah. But basically, digital evidence, the pinging of cell towers, the location of the car. They do have the eyewitness stating the man with the bushy eyebrows, the DoorDash driver, all of that. The one thing that this will put to rest, let the families move forward, but also all of those that were involved, that still lived in the house, that were friends, all of those that came later and discovered the bodies and helped with the 911 call, all of those friends and family that were on the outskirts of this violent crime won't have to relive it, won't have to testify to their experiences, and can move forward also. the same kind of, I don't have any further evidence. I didn't see any further evidence presented, but it was the same kind of questions we have heard when some people went pro se. Yeah, that's another thing. Well, we will definitely do the sentencing live. We will book out those dates, you know. I don't want anyone else to go after. They have been, Liam. Liam posted, I do hope the socials don't go after the housemates. They have repeatedly gone after the housemates. One of them had to leave the area, and she actually needed to be subpoenaed to come back for trial because she just didn't want to deal with it. It was so horrendous. Couldn't even get a cup of coffee in that town. They didn't understand why they didn't call sooner. You know, everyone made speculations. You know how it is when people get into their armchair detective mode and they think that they know the best thing that should have happened. And yet they weren't the one in the situation, you know. These were young adults, and it was a party house. It was the weekend. They several members of the household had gone out to parties and were drinking. You know, I don't know how anyone can actually judge them for anything that they did. You know, it's just going a little bit too far. I do believe that they did receive some harsh treatment on the socials. But as I have learned, the socials is a harsh environment to begin with. Unless you've got a little corner like this of your very own where you can talk to people and you're all kind of similar in how you approach things. Although I welcome the other side of any opinion, always, you guys, when we don't agree, I want to hear from you. Well, how was Bryan's parents dealing with this? Well, I couldn't really see who they were. We didn't get to see everybody in the galley, but I had read that they planned to be there for this because he needed to speak. And I do believe that they have spoken. They must have been with him in this agreement in some way. I'm glad. I think they would be like anyone of two minds, perhaps relieved that there won't be a trial, the torment of weeks of being there every day and hearing horrible things, but also having to settle with the final knowledge that yes, he did it. He's saying he did it, and he is going to take accountability for it. I would imagine it's bittersweet. Very bittersweet. Not having to go through the whole trial, but also knowing that your child is never going to see daylight again. He's going to be locked up for the rest of his life. And everything you thought for his future is gone. You know. Yeah, I believe that's true tomorrow, kiddo, who states if we knew your own child had committed a crime, you would want them to be honest about it. I would say that that is an outcome that, you know, the best possible scenario. Take accountability and do it. End the suffering of the families as quickly as you can. This took a long time to get here. This happened in 2022, and it took quite some time for Bryan Kohberger to get to the point where he's accepting a plea deal, as it is to the prosecution actually offering one. We don't know if one was offered in the beginning or not. I don't recall ever hearing of it. But this was a buttoned up case because of how huge it was in the town, university town, students everywhere, afraid to go back to university, not knowing what happened, not knowing why. And we still don't know why. And on that, there's always more people affected by a violent. Exactly. Everyone in the neighborhood thinking about that car, like, why did they walk into that house and not this? Yeah. I understand, Maggie. Yeah, that kind of threw me, Liam. That really shook me. What kind of people send out, like, try to get a hold of the court and the judge to influence him? How do they even think that's appropriate? Like he said, it is totally inappropriate in our system to do that. Who did they, like, you can't do that. the victims' families, and I know that many people were upset and they feel for the families. We all do. Well, their voice is with the prosecution office. That's where you make your calls. That's where you make it known. In regards to the plea deal, that's the system. Going to the judge directly and to the court, the members of the court there, trying for his staff, wow. And he was quite annoyed. We got annoyed Judge Hippler from the start, saying people have crossed the line again. Then he hates these high-profile cases. That's what he did not like about this case whatsoever. He didn't want to have anything to do with it, but he got assigned. And it's been a bone of contention with him from the start. So, on that, let me just check if you guys have any other comments or statements, but I think I'm going to wrap that one up. Meanwhile, there are other cases today where people aren't honest. Terrible, awful crime, no justice. I understand. It is hard. It is hard. It doesn't always go the way. It's an imperfect system for sure. Well, this is the best one that we have right now. It does need some, it could definitely need some sprucing up. It could use some sprucing up. I think they might have the family. I do think that the families were put off camera. I think the respect of their privacy would have been paramount. Yeah, yes, that's an appropriate title, Bandwagon Ghouls. All right, everyone. I'm going to call it. The next thing I have planned is on Saturday. I'll be back with Record to tie it up the 50th Law. Tell you what we have planned for the future. Streaming together. And I do not believe we're on jury watch anymore. Jen, the verdict is in. I'm going to make a community post, but for those of you, he was acquitted, not guilty on the RICO, not guilty on sex trafficking for both Cassie and Jane, but he was convicted guilty of the actual crossing of straight lines for prostitution purposes for both Cassie and Jane, 2 counts under the Mann Act. And that particular charge carries a sentence of 10 years for each offense. So he's looking at possibly 20, but first time offender, yada, yada, whatever. We'll see. Right now, they were starting at 1 o'clock. They were discussing bail. And the judge took a break from the bench and was coming back at 1 o'clock to discuss bail. What the state is actually adamant that he shouldn't have it. They were serious charges and he's been acquitted, but still the prostitution charges, still guilty. And since he was actually in jail, he should wait until sentencing to be released. So we'll see. We'll see. But the defense is offering $1 million in bail, saying that, he should be able to see his family, blah, blah. We'll see. The arguments are going back and forth. There are many accounts on X that are saying exactly what's going back and forth between judge and everybody out there, trying to give a detail. And I know Law and Crime was covering it. They've got Elizabeth Milner inside, several people outside. They still were live when I went live because the judge was coming back into the courtroom at 1 o'clock with everybody. So that's where that is. I'll give a summary on my community post. I don't think I'm going to do another live on Diddler. Not this week. I'm hoping that we will have a sentencing next week. We won't be able to go inside the courtroom, but we'll definitely have a post summation on the Diddler case in general. Let you all say your piece, once we find out everything that's going on. I'm sure we're going to hear from juries members out there. I would like to know where their head was, so I'll be looking for those interviews for sure to see if we could try to piece together what they were thinking about. Well, on that, I'm going to say have a good afternoon, everybody, a good evening, a good morning, wherever you are. Thank you so much for your support. Please like, share, comment on the back of the videos. It helps with the algorithm. I greatly appreciate you here in the chat, keeping me company and giving me your opinions and your questions. And that's the best part for me, is interacting with you all. it's like my friend group of true crime gets bigger and bigger with everyone coming in. And I really love your voices. I love your opinions. Love answering and talking about the questions back and forth and researching things together, because none of us really have it. I mean, I'm no lawyer. I don't know, but I love researching all of this with you all. So until the next one, I will see you soon. Good night.